Hello, everybody, or welcome back to my channel. Well, today they had the interlocutory hearings with Crikey and Lachlan Murdoch, or Lachlan Murdoch and private media. It took a whole day. In fact, Crikey's lawyer didn't actually get to speak until about 3 o'clock. The rest of the time was Murdoch's lawyer. It's very, very, very interesting. And it was all around this question about public interest and whether something that occurred in the US is a public interest story for Australia, and also all over reputation. I watched quite a bit of it. As I said, I think I got on about 11 o'clock and it finished about 4:30. So just before my exam. I'm just on an exam study break at the moment. But anyway, let's have a look. Only The Guardian has picked up this story to date. So we're going to see what Amanda Mead has said, and then see whether we've come up with the same summaries. What's in the public interest? Murdoch and Crikey trial could test new defamation defence. Lachlan Murdoch says independent Australian publisher can't rely on defence after it connected media baron to evidence at hearing into January 6 riots. Now, the last paragraph of the actual letter refers to Murdoch. It doesn't actually refer to Lachlan Murdoch. Murdoch is not actually, but Crikey is saying that because Murdoch is in charge, he's responsible for what his outlets produce. Lachlan Murdoch's role as the controller of his family's media conglomerates in the US and Australia was inseparable from the reputation of those organisations, the federal court heard. The relevance of Murdoch's leadership of the US Fox Corporation and its role in the January 6 riots was discussed at length in the preliminary hearing for the upcoming defamation trial against private media's Crikey. Lawyers for Murdoch say article falsely claimed, among other imputations, that Murdoch illegally conspired with Trump to overturn the presidential election result and knowingly entered into a criminal conspiracy with Donald Trump and a large number of Fox News commentators to overturn the 2020 election result. Murdoch's barrister, Sue Chrysanthou, SC, wants parts of Crikey's defence struck out because she says they are irrelevant, embarrassing, and will waste time at trial. Chrysanthou argued on Monday that it was not necessary for the court to watch an incalculable number of hours of Fox News coverage to establish whether Crikey could successfully use the new public interest defence. She argued the new defence, which has not been tested in a case yet, was not applicable to Crikey. The new dawn promised to the media by reason of this defence is not going to happen, she said. But private media's barrister, Michael Hodge KC, so that's a King's Counsel, they used to be QC, Queen's Counsel, so he's a King's Counsel, said the context of Murdoch's role at Fox and the lies told by Donald Trump and Fox News commentators about the US election were relevant to the public interest defence. It is either true or untrue that Rupert Murdoch, members of the Murdoch family who control these global media conglomerates, and Lachlan Murdoch have not disavowed the lies about the presidential election, Hodge said. Justice Michael Whitney said the issue of what could be argued as a public interest defence under the new defamation laws was complex, and he reserved his decision. To rely on the public interest defence, Crikey needed to show politics editor Bernard Keane had a reasonable belief that what he wrote was in the public interest, Chrysanthou said. We are saying that no matter of public interest that connected my client to the US Capitol hearing evidence, Chrysanthou said. In August, the co-chair of News Corp filed proceedings for defamation against independent news site over an article by Keane headlined, Trump is confirmed unhinged traitor and Murdoch is his unindicted co-conspirator. Chrysanthou on Monday said the only co-conspirators identified were persons with my client's surname and Fox News commentators. In the final paragraph, Keane, out of nowhere, compared her client with Richard Nixon, an unindicted co-conspirator of the Watergate controversy, the barrister said. The article was about a criminal who had committed an inindictable offence and got away with it. And the reader is told there's an extensive evidence of my client engaging in a plot with the unhinged trader Trump, so-called. That's what this article is about. Murdoch is also claiming Keane and Crikey's editor, Peter Fray, were motivated by malice, predominantly acting to harm Murdoch. Private media has applied to have the claim struck out. It has denied the article defamed Murdoch as alleged and will argue it didn't cause serious harm to him. Murdoch is seeking aggravated damages and an injunction to prevent Crikey from republishing the article and its imputations, and the 9-day trial is to start in March 2023. So today's argument was about having items struck from the defence and items struck from the claim. That was what it's about. And whereas Justice Whitney had hoped to be able to rule today, he said it was too complicated. So he's taken it away. He's got to go and look at case law. This is, as I said, this public interest defence is actually untested. And there was lots of English law. So I'm actually going to post the link to the whole proceedings down below, because it was actually put on YouTube, live on YouTube. I think they just figured it was people were going to watch it. So I'll put it there if you really want to watch it and see how Australian courts go. But yeah, it's very interesting. And look, there's with these matters, there's a lot of the judge will ask questions because he's on this needing to make a decision, and so we'll ask questions. We'll test to see the barrister's knowledge of the law. Quite often we'll push the boundary. We'll talk about cases. Well, isn't this or the defence argues this? How can this not be right? And then when the defence or when the defendants were talking, he'd say, but the plaintiff alleges this. How is this not this? And it was really interesting to see the interaction. So I'm going to post that in the description box. Anyway, I hope you have a good one. And I'll catch you next time. And we've just got to now wait for either a decision, or we've got to wait until we just have to wait for a decision now. But there's been lots of filings. There's lots of submissions and everything like that. Anyway, I'll catch you next time. Bye for now.